Hello, everybody.
All right, calling case number 24004-02701FH, People of the State of Michigan versus Chance Bond. Parties, your appearances, please.
Good morning, Your Honor. Patricia Mandry, for the people, P840088.
Yeah, good morning, Your Honor. Robert Jerzik on behalf of Chance Bonham. I'm appearing by Zoom, and I believe is he there in the courtroom, or is he on Zoom from the jail?
He is here in the courtroom.
And I'm sorry to interrupt, Your Honor. Do we have a complaining witness, Brandy Malone, in the Zoom waiting room?
Yes, we do.
Thank you. I would just ask that she be admitted so she can observe.
Sure.
Thank you, Judge.
All right. And Miss Malone, let's see. Well, I guess if she's not stating anything, she doesn't need to state her appearance. Okay. So we are here today for a final conference in Mr. Bonham's matter. And where do things stand at this time?
Your Honor, I recently conveyed an amended plea offer to defense counsel. The current plea offer in this case is that defendant pleads guilty to count 2, assault with intent to do grave bodily harm, less than murder or by strangulation. In exchange, the people agree to dismiss counts 1, 3, and 4. Additionally, 34th District Court case number 24-0675-FY, which is an aggravated stalking case with the same parties stemming from a bond violation. In this case, that the egg stalking case will be dismissed as well. There's a sentence agreement. Defendant would be sentenced to 3 years probation, first 6 months in the Wayne County Jail. Defendant must complete DBT. Defendant is eligible for early release upon completion of DBT. Defendant must complete substance abuse evaluation and any recommended treatment, and mental health evaluation and any recommended treatment. No contact with Brandy Malone except pursuant to a custody and parenting time order. Any other terms and conditions ordered by the court.
All right. Thank you. And is that a new offer, or has defense received that offer previously?
I conveyed this offer to defense a couple days ago. It's just a brief, the only term that was modified is it went from no contact with Brandy Malone to no contact with Brandy Malone except pursuant to a custody and parenting time order. Complaining witness is currently pregnant with defendant's child.
Okay. All right. Thank you. And what's defense's position at this time?
Your Honor, I've spoken with my client, and he does not, and at the last time I spoke with him, he does not wish to avail himself of the offer made by the prosecution.
Okay.
Unless Mr. Bonham has reconsidered or changed his mind since then, I'm not aware of.
Okay. So, Mr. Bonham, is it still your wish to proceed to trial, sir?
I have a question before I answer that, if I may speak.
Yes, I just, it's not about the facts of the case, is it?
No, sir.
Okay, all right, then.
So on August 1st, this motion was put into the court where you granted my bond with the conditions, correct?
So let's see here.
250,000 cash for surety with GPS tethered, curfew 10 to 4 a.m. No contact with complaining witness. Cannot return to protected address.
Yes, that is what I have.
So I attempted to post said bond and was told that I did not have a bond. So I've been here for the past 44 days. 9 of those days I haven't had contact with my attorney or my family. I've been assaulted, I have a fractured hand. So before I even proceed with this, I would like to ask that I can have some type of bond so that I can, at the very least, make some money to take care of my child. I'm on the verge of losing everything. A house, a car. There's only so much grass that can be cut before the season is over. I've missed out all of that. So I don't know how that plays in this situation. It's not that I'm not wanting to take the plea. I just want to take care of my affairs, see my son be born, and then I'll gladly sit for 6 months if necessary.
Okay. Well, as far as the plea offer, that I'm going to leave for you and Mr. Jerzik to talk about. But as it relates to your bond, I don't know why. So was it a bond bailsman that told you they didn't, that you had no bond, or was it someone from the sheriff's office?
But
Both.
my bond, when I went to post my building, they told me I did not have a bond. Whenever I spoke to the new attorney that is representing this new charge that they're trying to force me into as a condition of taking this plea, she also told me that she can see right there where this paper has been filed, where the motion was granted, but in their system, it still says that I'm remand. So I was not able to post my bond.
I don't know why I would say remand, because I see. Now, is that the Corporal Brzezinski, is that the order that he has in his hand?
Yeah, that's the bond or motion or bond motion.
Now, when they told you that you did not have a bond, did you happen to have that with you?
Yes, sir.
So you showed it to them, and what did they say?
Showed it to him.
Well, okay, so someone told you you do not, there is no bond that you can
So the
post.
bail bondsman.
Did you
said
show
that.
them that order?
Yes, the bail bondsman said that. I read this to my family, who conveyed it to them. They told me that to the best of their knowledge, that the best that they will be able to do is on yesterday's date at that court proceeding, that it will be addressed. When I talked to Miss Tamika Tucker, she confirmed from what she could see that I was still remanded.
In both spots where I can look at bond in our system, I do not see that. What do you see in your?
So this is just that I use, but they do have some kind of remand for something here. I don't know what the saying what, but there
What is
is a
it for-
remand. I don't know
What
what
is
this
that? Our, let's see
bond.
if that's our 7.
I don't know what this bond number is though, because it's not.
Right, those don't
Case
match up
number.
with the cases.
Case number is here.
And that doesn't make sense because our bond is not either of those. So it's a 250,000 cash sure.
So does he have two cases?
He does have a second. So your second case is at 34th District Court, was it?
Yes,
Not
Judge.
arraigned.
Defendant has a second case at 34th District Court. He's charged with ag stalking. As I indicated earlier, stemming from a bond violation. In this case, I won't go into more detail unless the court would like. That case, we just had the PCC for it yesterday. Or I'm sorry, not yesterday, Wednesday, September 9th, 2024. And that's currently set for a preliminary exam on October 23rd, 2024. And I would like to address the possible joinder issue with the court when the court.
Are you the prosecutor on that case as well?
Yes, Judge.
Do you know what the bond is in that matter?
Yes, Judge, I have it up in front of me. In that case, defendant was given a $10,000 PR bond.
May I speak?
Yes.
I have not been arraigned on that matter. So I just don't understand how that makes because that wasn't filed before this date, to my knowledge and my understanding, unless you guys know something that I haven't been privileged to.
So what you're saying, you have not been arraigned on that case, but you
No,
said
sir.
there's a, but didn't you say there was a PCC yesterday?
Yeah, Judge, we just had a PCC for the ag stalking case yesterday where we set it for an exam on 10/23/2024 at 11 a.m.
When I asked the judge, she told me through her mouth, I am not being held on that matter and that it was to be reviewed. I have not been arraigned in that matter. I have not seen a judge. I sat down. She told me that it would be reviewed and I walked away. I never gave my name. I never gave a testimony, a statement or anything of the such. I was never arraigned.
Okay. The people are now aware of that issue. I'm gonna leave that up to the district court. But maybe the people can raise that issue if they'd like to rearrange you. As it relates to bond issue in this case, no, Corporal Brzezinski, is there anyone that could maybe tell you what that bond number is associated with, so we could try to figure out why?
Well, I have a potential remedy. I have the MIT. and
Okay.
I have the order, the same copy. I have the clerk print me another copy. And when I take him back over there, I will make sure that the computer reflects this order. I don't know if it was just a clerical thing and it didn't get properly updated. I
Okay,
don't know. I don't
okay,
work over there, so I don't know, but I will personally make them pull it up and enter in this in front of me,
okay.
if
All right.
that'll help.
Yeah, oh, yeah, no, that would be very helpful. Thank
Your
you.
Honor,
Yes,
can I please have a 10%? Is that possible so that I can That's something that I can manage. If I pay this money, that's $25,000 that I don't have, that I'm gonna have to borrow. That is more food out of my child's mouth. At 10%, I can manage it. I can do what I need to do, get my affairs together, and I will sit here in Wayne County Jail for 6 months with a smile on my face, knowing I've done what I need to do as a man, with your grace.
Judge, would the court like the people to respond?
Sure.
The court set the bond so high in this case because of the aggravated stalking. In part because of the aggravated stalking case where defendant came to complaining witness's home in violation of the no contact order. If I recall correctly, we have defendant on ring camera video. Defense counsel can correct me if I'm wrong. We have defendant on ring camera video attempting to enter through complaining witness's front door. When he fails to enter, when he can't get through the front door, he goes around to the side of the house, which is where complaining witness's bedroom window is. He bangs on the door. You can hear him telling her to open the door and demanding entry into the house in the ring video. He does this a couple times in the middle of the night. I believe it was at 2 a.m. And then the next day he comes back in the afternoon when complaining witness usually leaves for work, and again attempted to enter through the front door, failed, and attempted to enter and then went to complaining witness's bedroom window. Additionally, Your Honor, during this incident, during the case in front of the court currently, when defendant was assaulting complaining witness, defendant told complaining witness is currently pregnant, as I stated earlier. She's due in November. Defendant stated during this case, when he was assaulting complaining witness, that he was trying to induce an abortion in her. And additionally, Your Honor, at 34th District Court at the date scheduled for the preliminary exam in this case, defendant approached complaining witness outside of court and asked complaining witness what happened to not showing up to court. We had a bond hearing at the 34th District Court on the day of the exam. During that hearing, defendant admitted that he had been living at complaining witness's residence for a period of time in violation of his bond. Defendant had multiple outbursts on the record where he admitted to having contact with complaining witness and expressed that he felt entitled to have contact with her because she is carrying his child. As the court knows, in domestic violence cases specifically, the lethality risk for a complaining witness skyrockets when the complaining witness is pregnant and soon after birth. So based on defendant's conduct of violating the no contact order by coming to complaining witness's house, his conduct of approaching her at the court and asking her what happened to not showing up to court, his own admissions on the record multiple times that he has violated his bond, and the fact that he has expressed that he feels entitled to contact with complaining witness despite the court's orders because she is pregnant with his child, I would ask that the court keep the bond as is for the safety of complaining witness.
May I rebuttal, Your Honor, please? If you may.
Yeah, briefly, yes.
So I never had an outburst the same way I'm talking to you as I talked to Judge Oakley. He asked me a question, I answered it. I gave him a specific answer to his specific question. I didn't lie, and it's not as though the prosecutor is trying to paint it. My attorney was present, and all of these matters are on the record. He asked me a question, and these videos that she is referring to have never been played in an open courtroom. I've never been arraigned on them. To my knowledge, they don't even exist. I have not received the discovery. I feel as though I'm being railroaded, and I don't think that's fair. And you, in your motion that was granted, you said a GPS tether. With a GPS tether, I have no way of going there. I have no intention on going there. I would like to work and pay what needs to be paid for my child only.
I understand both parties' positions.
And one more thing, Your Honor.
Okay.
Can
Yes.
we address the emails that were sent over? Because last that I was told that the complaining witness was not wanting to come to trial. That's what was shown to me. And so if I'm such a risk, why is it that my complaining witness is asking that I'm released so that I can take care of my child? Mr. Jerkins, can you please read the emails that you displayed to me?
Yes, I received an email in which the complaining witness has stated that she didn't wish to pursue this matter. In fact, she Yeah, she had stated that she didn't wish to pursue this matter.
Well, that may
Can
be
you read
the,
it word for word verbatim, please?
Hang on a second.
These are emails that were sent from the prosecutor.
I'm sorry, Judge, could the court possibly advise defendant of his Fifth Amendment right?
I am aware of my right to remain silent. Thank you very much. I would like to speak with my attorney. He's not present, so I'm speaking on my own behalf.
And additionally, Your Honor, I would ask the court to direct defendant that I am not allowed to speak with him or respond to him.
I addressed it to you, Your Honor.
okay, so,
My apologies.
so I do want to remind you, I know you
Yes,
just
sir.
stated that you're aware, but you do have your Fifth Amendment right.
Yes, sir.
And yes, you cannot speak to the prosecutor directly. Those communications need to happen through your attorney, Mr. Jurzik.
Yeah, he said well, just hoping there is a plea deal change because I won't be there for trial. I have personal things going on with my kids. And I'm still working 7 days a week. I don't have family or friends. I don't want to have his baby alone. He deserves to be there for the birth of his son. I know this man. I'm not dismissing what happened, but he needs help, not sit in jail. I don't
Okay.
believe he needs jail time or be kept from his son. I truly believe he needs therapy because I'm begging that you guys will dismiss all charges under the circumstances and that he does and takes anger management, sustains and maintains employment for a consistent schedule, and mental emotional therapy, and give him time served anger management, employment therapy.
Which are all things that I will gladly do with the grace of you.
Okay.
And
So.
I'm
well,
sorry, Judge, may I just briefly address the email?
Yes.
Your Honor, I forwarded the email to defense counsel, because I know we say this all the time. Our office is an office of justice and we operate in the sunshine. So of course, upon receipt, I'm forwarding that to both of his attorneys. I spoke with these emails were sent, the last one was sent from complaining witness Monday, September 9th. I spoke with complaining witness at length on Wednesday, September 11th about this case. I confirmed that she is on board with the current plea offer. I confirmed that she still wants to participate in prosecution
All right. Thank you.
in both cases.
Excuse me, Your Honor.
Well, I think, Mr. Baum, at this point, we have allowed you to speak quite a bit, but I think I'm gonna leave it to Mr. Jurzik at this point.
That's what I want to ask a question towards him. I don't know how to do that without him being present. That was my question.
You have a question for Mr. Jurzik?
Yes.
Can I
Okay.
speak?
That was my question, if she could speak.
No, Ms. Malone,
No,
I'm sorry.
Yes, typically we do not allow complaining witnesses to speak until.
My apologies.
It's okay, Ms. Malone. I know you're probably not familiar with the court process, so that's quite all right. Mr. Bonham, we will allow you to ask Mr. Jurzik one question before we close this matter.
That was my question. I was wondering.
Oh,
was able
if she
to
could,
speak on
if she
her
was
own
able to.
behalf.
Okay, not today. That would, the complaining witness, we reserve their speaking until the time of trial when they would testify, if we get to that point. So thinking maybe we should return just once before we have our trial coming up on September 30th. I think maybe we should all be here in person on September 27th, if that works for everyone, just so that we can have one final meeting before we proceed to trial that following Monday.
May I ask one last question, Your Honor?
Yes,
Thank-
Mr. Baum.
Is there any way that I can be released between now and trial? I've tried everything that I can do in my power, and I at this point, it's not worth me to spend $25,000 to only have 3 weeks of work. I have somewhere to go. The GPS tether, I think, is sufficient.
I understand, Mr. Baum, but I've made my decision as it
Understood.
relates to Baum.
But I just had to ask. I appreciate
No,
it.
that's, so we will come back. So Mr. Jurzik, are you available for a final pretrial on September 27th?
I think that's the Friday before, yes.
Okay, we'll all appear in person that day. That way we can go over any final issues as it relates to trial or potential settlement. Anything else though for today?
No, Your Honor.
Anything on behalf of defense?
Not this time, Your Honor.
Okay, all right. We will see everyone back in 2 weeks from
All right.
today on September 27th. Thank you.
Thank you, Your Honor.
Okay. Thank you.
Be safe, be well, sleep sweet, and much love.